Module 4. Avoiding defamation claims. There are 3 stages in the preparation of an article for publication: research, writing, and final steps such as seeking comment before publication. NGOs and campaigning organisations can get the best protection against defamation claims by acting responsibly at each of these 3 stages. The best possible protection against being sued for libel is to publish accurate information that you could prove to be true if required to do so. Factual accuracy is vital for a truth defence, but is highly relevant to all the other defences as well. The basis for an accurate, defensible publication comes at the research stage. Undertake thorough research before publication. Try to find reliable sources. If you will rely on the evidence of witnesses, take written statements and get them to read them through and sign to indicate that they agree the contents. Try to find written evidence to back up the accounts of witnesses rather than just relying on witness evidence. It's important to look critically at your evidence and to double-check critical facts. If a witness makes a serious allegation against a person, don't take it at face value. Ask questions to satisfy yourself whether it is accurate and reliable. Ask yourself, is this something the witness has seen firsthand? Is this something the witness would be in a position to know? Is this really evidence of the wrongdoing the witness is alleging, or is it consistent with a different kind of wrongdoing, or even an innocent explanation? If you want to rely on other publications, remember that it isn't a defence to republish information already published elsewhere, so try to rely on reputable publishers. Wherever possible, make good use of official publications, such as government reports or the reports of international organisations, which are protected by privilege. Remember also that fair and accurate reports of proceedings in Parliament or international conferences, for example, are also protected by privilege. Once you have collected your statements, notes, and copies of other publications, make sure you hang on to them for at least 1 year after publication in case you ever need to defend a claim. If the case ended up in court, you would need to explain each of the steps you took prior to publication. In some cases, you may be lucky enough to have clear and reliable evidence of wrongdoing that you feel very confident you could prove to be true if you were sued for libel. But in many cases, it's not possible to be so confident. Let's say your organisation campaigns to save the rainforest, and villagers from Brazil have alleged that a UK company is involved in illegal rainforest destruction. You may have received credible reports from the villagers, and you may be satisfied the area is a protected area, but you may have doubts about whether the British company is involved. Let's imagine that at the research stage you felt there was some but not conclusive evidence of the company's involvement. In these circumstances, it would be high risk to publish a report alleging illegal rainforest destruction by the company. But you might be able to publish a very similar article pointing to the evidence of the company's involvement, saying that the company failed to respond when the allegations were put to it, assuming that was true, and calling for an inquiry. By doing this, you have drawn the same issue to public attention, but without making a risky direct allegation of wrongdoing, the truth of which you might find it impossible to prove. This relates to the levels of defamatory meaning discussed in Module 2. The more serious the allegation, the harder it will be to prove the truth of it, and the harder it will be to succeed in a public interest defence. So you can manage the degree of libel risk to a significant extent by adjusting the seriousness of the allegations you make to match the strength of the evidence you have to defend a potential claim. In some cases, a source will want to be anonymous, and that must be respected. But where sources are willing to go on the record, it adds credibility to a publication to attribute specific allegations. Likewise, where you rely on another report or article, it's important to cite it. Tone is also important. It's much easier to use the public interest defence to defend an article that is written responsibly than it is to defend an article conveying very similar information that has been written in a sensationalist way. Remember also that some targets for criticism are safer than others. Central government, local government and political parties can't sue in England and Wales for defamation, so there is little risk criticising them. While government ministers and officials can sue in an individual capacity if they are identified in a publication, the bounds of acceptable criticism are wider for people who occupy such positions. Likewise, companies will often find it harder to sue as they would have to show that the publication is likely to cause serious financial loss. However, individuals, and in particular wealthy individuals, will find it easier to sue, and extra care is required with them. An important issue to decide is whether, before publication, you want to seek a comment from the person or company against whom you plan to make a defamatory allegation. In some situations, there may be good reasons for not giving prior notice, for example, if doing so could expose an in-country source to danger. But in many cases, giving notice of the allegation and an opportunity for comment is important, as this is part of the fairness expected of a responsible publisher and makes it more likely you would succeed with a public interest defence if you were sued. Giving an individual or company the opportunity for comment usually makes it less likely you'll be sued. It's a normal human reaction for people to react more violently when they are taken by surprise by a defamatory publication. If you give the person or company concerned the opportunity to comment, it can take some heat out of the situation. In addition, putting the substance of a factual allegation to a potential claimant can be an effective way of checking if a story is accurate or if the claimant has a credible answer to the allegation. Sometimes an answer that is just general PR guff and doesn't address the substance of an allegation is a telling indication that the story is true. It is very difficult for anyone to get an injunction in advance to prevent the publication of a defamatory allegation in the UK. This means that you can usually be confident that putting the allegation to the person concerned won't jeopardise the publication, just delay it. The position regarding injunctions is different if the publication involves confidential or private information, where injunctions can be obtained more easily. If a defendant does give a substantive response to the allegation, it is wise to include some reference to that response in your publication. Sometimes it suffices to refer to a denial and maybe include a link to the full response. At other times you may wish to quote or paraphrase part of a response. There is no golden rule about how extensively you need to cover a response. It's a matter of judgment and depends on the facts of each case. If the potential claimant doesn't respond at all, you should refer to the lack of any response in your publication. If you are publishing a press release at the same time as a full report, take particular care with the press release, as it's a separate publication which a claimant can sue on independently of the main report. Often press releases are produced at the last minute and errors tend to creep in. There is also a tendency to hype things up in a press release, which may mean that you end up publishing a more serious allegation in the press release than in the actual report, which carries additional libel risks.